If you own rental properties in California, you already know one oversight can turn years of hard work into legal headaches. Most problems don't start with a big mistake. They start with something small like titling property in your personal name, assuming an LLC alone will protect you, or overlooking the fact that California gives creditors far more access to your assets than most investors realize. I'm Ali Talai, an attorney here in California focused on estate planning and asset protection planning for real estate investors. In this video, I will walk you through 5 high-risk rental property mistakes I see all the time and the asset protection planning that can literally keep you out of the courtroom. You will learn how to structure your entities, cross jurisdictions, protect equity before it becomes a target, and build the kind of defense plan that stands up when California law is tested against you. Let's start with one of the most common foundational mistakes I see: holding California rental properties inside of a single member LLC. Now, owning real estate in your personal name is the worst case scenario because one incident could expose all of your personal assets. So yes, an LLC is essential. It keeps a tenant claim or lawsuit contained at the property level instead of reaching everything else you have. But here's the part most investors never hear. A single member California LLC is significantly more vulnerable than people realize. California's creditor remedy law allows courts to go beyond a simple charging order when that remedy alone isn't enough to satisfy a judgment. Under California Corporation Code 17705.03, a court here in California has the power to foreclose your membership interest, force a sale of your interest, appoint a receiver to take control of distribution, or even compel distributions directly from the LLC. Now, technically, those remedies exist for multi-member LLCs as well, but courts almost never use them when there are other non-debitor members who would be harmed. And that is the key difference. In a single member LLC, there are no innocent member to protect. So judges feel completely justified in stepping all the way in and giving the creditors effective ownership or control rights. This is why relying on a single member California LLC, even with a comprehensively drafted operating agreement, creates exposures that many investors simply don't see coming. To build a stronger structure, we introduce what I call protective friction. This can be accomplished by, let's say, converting the LLC into a genuine multi-member entity where a legitimate non-spousal second member is added. This member can be an irrevocable trust that names your children as the beneficiary. Now, when we have more than one member, a court has to consider the rights of the other member, and that makes the more aggressive remedies far less likely. A second method is using a Wyoming holding company. Wyoming offers statutory charging order protection even for a single member LLC. So the structure becomes your property goes inside of the California LLC, and then the California LLC is owned by your Wyoming holding company. Now a creditor has to deal with California law at the property level and Wyoming law at the ownership level. That cross-jurisdictional hurdle creates delays, complexity, and cost, which is exactly the deterrent effect we're trying to achieve. Before we even get to the LLCs, many investors start with a land trust for privacy. The land trust's trustee's name shows on title, not yours if drafted correctly, and you can later assign the beneficial interest of the trust to your LLC. That way, you're shifting control behind the scenes without recording a new deed that might draw attention to any due on sale clause in your loan. So the full modern structure looks something like this. Property goes inside the land trust. The land trust names the California LLC as its beneficiary. The California LLC is owned by the Wyoming Holding LLC. And then the Wyoming Holding LLC is owned by your revocable trust, your irrevocable trust, or your adaptive trust. This is a kind of a trust that starts as a revocable trust and it could turn into an irrevocable trust if there's a lawsuit or some sort of event that happens in the future. This approach combines privacy, local liability segregation, and out-of-state charging order protection. and also probate protection, all working together to create a much more resilient and sophisticated defense around your real estate portfolio. The next mistake is getting cheap on insurance or forgetting to update your coverage as you grow your property portfolio. Basic homeowners insurance is not enough. You need a specialized landlord policy, but even more critically, you need umbrella coverage. Insurance is your first line of defense. Without umbrella coverage, your assets are on the hook if you get hit with a massive judgment. You must regularly review your policies for exclusions or outdated owner-occupied designations that could invalidate your coverage. Another mistake that quietly undermines an investor's entire structure is failing to maintain a clear separation between business and personal finances. Even when someone has taken the time to form an LLC or a multi-layered entity structure, that protection can evaporate if the entity isn't treated as a truly separated business. Courts in California apply a substance over form analysis. That means they don't just look at your documents or your operating agreement, they look at your behavior. If your personal and business funds are mixed together, if the LLC doesn't have its own designated bank account, or if the expenses are casually paid back and forth without proper documentation, a judge can just conclude that the entity is merely an extension of the individual. When that happens, the court can pierce the corporate veil, making the owner personally liable for claims that were supposed to be contained within the LLC. Another major area of exposure for rental property owners in California, in LA County, in the city of LA, comes from a place many investors overlook, and that is the strict and ever-changing tenant protection laws. In this state, the legal landscape surrounding the rent control, just cause evictions, relocation assistance, notice requirements, and security deposit procedure is constantly shifting. Failing to keep up with these rules doesn't create inconvenience, it creates liability. What often surprises landlord is how easily a routine management decision can turn into a legal claim. Something as simple as issuing a defective notice, misunderstanding a local rent cap, or mishandling security deposit can escalate into substantial financial consequences. California allows tenants to recover attorney fees in many housing disputes, which means even a small procedural error can become an expensive problem. I want you to keep in mind that advanced asset protection is not just about forming LLCs and trusts. It's also about preventing avoidable claims. When your management practices align with California's statutory and local requirements, you dramatically reduce the likelihood of litigation, keeping your structure intact and exposure low. Even with strong entity structure in place, LLCs, holding companies, and privacy layers, many investors overlook the outer layer of a complete asset protection system. Entity structures can separate liabilities between properties and limit exposures, but at the end of the day, you still own the LLC interest. And anything you personally own can, under the wrong circumstances, become a target. This is where advanced trust planning becomes essential. In California, despite not recognizing self-settled asset protection trust, provides extremely strong protection through a properly drafted third-party irrevocable trust. Under California law, you cannot create an irrevocable trust for your own benefit and expect creditor protection. That is not going to happen. But when you create an irrevocable trust for someone else's benefit and you are not a beneficiary, California provides robust protection, and most importantly, this protection is immediate. Unlike Nevada or other domestic asset protection jurisdictions that impose a seasoning or a clawback period when the grantor is named as the beneficiary, a true third-party irrevocable trust under California law becomes protective as soon as it is funded. But a lot of times when I talk to investors, they worry that if they're not the beneficiary of that, they will lose control, or if the trust is irrevocable, they will lose control. But irrevocable trust, if drafted carefully, can allow significant flexibility without jeopardizing protection. For example, what are these flexibilities? I can draft the trust for you that would allow you to retain a power of appointment, which would allow you to change beneficiaries. You can have the power to remove and replace the trustee of the trust. You could have the power to borrow money from the trust or substitute assets of equivalent value, or even veto certain trustee decisions. And for added flexibility, you can appoint a trust protector, a neutral third party with the authority to modify certain provisions over time, including the power to add the grantor as the discretionary beneficiary in the trust at some time in the future. Of course, such an addition may compromise protection by restoring beneficial enjoyment to you, but when used strategically, this flexibility allows the trust to adapt without sacrificing its initial strength. Some investors want a structure where the grantor is a discretionary beneficiary from the outset. This is the role of a domestic asset protection trust in states like Nevada, South Dakota, or Delaware. There are more states that have these domestic asset protection trust jurisdictions or these sort of laws. These trusts allow the grantor to benefit from the trust while enjoying a degree of statutory protection after that seasoning period, after the clawback period. Typically 2 years in Nevada. The other states have different timeline. However, when a California resident uses a Nevada asset protection trust or any other asset protection trust, the protection is not absolute. California has a strong public policy against self-settled asset protection trusts, and California courts are not required to apply Nevada law to California residents or California situs assets. However, the goal of asset protection is that we want to create some sort of a structure that makes it a lot more difficult for creditors to reach, and a DAPT jurisdiction, irrevocable asset protection trust, will definitely create some friction and it will make it more difficult. But if you're a California resident, I would probably recommend that we would set up a California third-party irrevocable trust where protection is immediate and fully enforceable. For even more adaptability, we can create a hybrid domestic asset protection trust. These sort of trusts start as a third-party trust offering immediate protection and include a provision allowing the trust protector to add the grantor as a beneficiary later. This approach keeps the trust compliant with California public policy at the outset while preserving the option to transition into a domestic asset protection style structure if future circumstances change. And for clients with high exposure or substantial non-California assets, a hybrid foreign asset protection trust offers an even greater level of deterrence. These trusts begin domestically for simplicity, but contain a mechanism allowing the trust to migrate to a foreign jurisdiction, such as the Cook Islands or Nevis if litigation escalates. These foreign jurisdictions do not recognize U.S. judgments. They impose significant obstacles to creditors and thus can provide a great deal of asset protection. Beyond trust, another advanced layer of defense is equity stripping, which focuses on reducing the visible equity a creditor might target. This strategy involves creating legitimate, commercially reasonable loans between related entities, such as between a Wyoming holding company and a California operating LLC, and securing those loans with properly recorded deeds of trust. When documented and operated as real transactions, equity stripping makes a property appear heavily leveraged. A creditor may still be able to obtain a judgment, but the collectible value becomes significantly diminished. The goal is not secrecy, but deterrence. A creditor who sees little or no recoverable equity is much less likely to pursue aggressive. Now that we have explored the major risks and the advanced solutions, let's bring everything together in a clear, strategic hierarchy of protection. Each layer serves a specific purpose, and the strength comes from how they integrate. We begin with insurance, including a proper landlord policy and umbrella coverage. This is your first line of defense, absorbing the initial impact of the claim. Next is privacy, often through a land trust, which keeps your name off public records and reduces visibility. Above that, you have the California Operating LLC, isolating liability at the individual property level, preventing one property's claim from affecting your entire portfolio. Then we have the Wyoming holding company that sits above that structure, adding a stronger charging order regime that protects the membership interest, even though the underlying property is in California. Then comes the equity stripping, which reduces the visible equity inside each asset through legitimate, secured internal loans. This makes the property appear heavily leveraged and significantly less appealing to creditors. And finally, the outermost shield consists of advanced trust structures. And that can be a California third-party irrevocable trust, which provides immediate and fully enforceable protection. It could be a domestic asset protection trust that offers additional options for clients who want to remain a discretionary beneficiary, though California residents must understand the public policy limitations. The other option is that we could have hybrid domestic and hybrid foreign trust combine these strengths, allowing the plan to adapt to changing circumstances while providing exceptional protection for membership interests, distributions, and out-of-state or liquid assets. When these layers are arranged thoughtfully, they create a system that is legally sound, multi-jurisdictional, and highly resilient, making your portfolio difficult to attack, difficult to reach, and unattractive to pursue. If you found these tips helpful, don't stop here. The next video is called Business Succession Planning. Don't leave your company unprotected in California. It is packed with essential advice for anyone who owns a business or real estate here in California. I will show you how to make sure your company or property ends up in the right hands and not tangled in months of court battles. If you care about what happens to your assets and you want to avoid nasty surprises, this is the must-watch video for you. See you over there.